People of the State of Michigan versus Scott Eugene Blair, 2023544. Mr. Blair is here appearing by video today with his attorney, Mr. Richardson, and Mr. Gabriel is the Chief Assistant Prosecuting Attorney. This case is set for a status conference today. I'm told the matter is resolved. So, Mr. Blair, please raise your right hand. You solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right, Mr. Gabriel, could you please restate what the offer was?
Yes, Your Honor. If the court accepts a guilty plea to the charge of assault with a dangerous weapon by Mr. Blair, we will dismiss the felony firearm mandatory prison sentence. I'm also going to make a recommendation to the court that if jail were to be imposed, it only be as a violation of probation, that there be no upfront jail.
Is that correct, Mr. Richardson?
That's correct statement of the plea agreement.
Mr. Blair, the offer in the case is that you plead to a felony charge of assault with a dangerous weapon. It's also known as felonious assault. It's a felony, which is a crime punishable by more than 1 year. This crime is punishable by up to 4 years in prison and or a fine of up to $2,000. Your DNA was supposed to have been taken at the time of your arrest, but if not, we'll take one now. And a consecutive sentence could have been imposed if the assault was committed in a place of confinement. The charge of felony firearm, which is a felony punishable by up to a mandatory 2-year sentence, so 2 years in prison preceding any other and consecutive to any other sentence, would be dismissed. And the prosecutor would agree to recommend no additional jail time, upfront jail time, and that's assuming that you comply with the terms of your bond and also the preparation of the pre-sentence report and the rest. So again, they're recommending that when we come back for sentencing, the court not impose any jail, but if you don't show up for your pre-sentence interview, if you don't have the pre-sentence report prepared, if you don't show up for sentencing, if you commit a new crime, then their recommendation goes away. You understand that?
Yes, sir.
Now, do you also understand that I had absolutely nothing to do with this agreement between the prosecutor and the defense, and I'm not involved in that? And so when we come back, if I look at the pre-sentence report and I say, no way can I do this, I can't go along with the no jail rec here, then I would be obligated to let you and your attorney know what my sentence would be. You'd have an opportunity to talk with Mr. Richardson about that. And if you wish to withdraw your plea, you'd be allowed to withdraw your plea, but then the original charges would be imposed. Do you understand that?
Yes, sir.
All right. Are you currently on probation or parole anywhere?
No, sir.
So how do you plead to the charge of assault with a dangerous weapon?
I plead guilty, sir.
Other than what we've talked about in court today, has anyone promised you anything else to get you to plead?
No, sir.
Anybody threaten you?
No, sir.
Are you doing this of your own free will?
Yes, sir.
And do you understand that if I accept your plea, you'll be giving up the rights you would have had at trial? And those include, no, I'm gonna have to do this from memory. Those include the right to be tried by a jury, to be presumed innocent, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at court and to question those witnesses. You have the right to have the court order any witnesses you want for your defense to appear in court. You also have the right to remain silent if you wish, and to not have that silence used against you. And in the alternative, you have the right to testify if you want to testify. You understand, those are the trial rights that you're giving up by pleading guilty.
Yes, sir.
You also understand that you may be waiving certain defenses that could have been raised and heard by pleading guilty, and that any appeal from your sentence and conviction would be by leave to the Court of Appeals and not by right. Do you understand that?
Yes, sir.
Okay. So really, because most attorneys don't understand that, but if you do, what it means is if you go to trial, you get to appeal everything. But when you plead guilty, you don't have an automatic right to appeal.
Exactly.
That's basically what it means. Do you understand?
Yes, I understand.
Okay. All right, good. All right, so Mr. Blair, it's alleged on October 9th of 2020, you were in Sturgis Township, County of St. Joseph, State of Michigan. Is that true?
Yes, sir.
And it's alleged that at that time you made an assault upon a Kevin Pritchard with a dangerous weapon, a gun. But you did so without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder.
Yes, sir.
So did you have a gun?
Yes, sir.
And did you assault Mr. was it Pritchard with it?
I shot off a few rounds, sir. Yes, sir.
In his direction?
No, sir.
Where at?
Towards my barn. I live on 190 acres of property, so I shot it at my old red barn out back.
But you were in an altercation or an argument with Mr. Pritchard, is that right?
Yes, sir. They were staying with us. We let him stay with us, and he came home drunk and got in my face in my dining room and was persistent to assault me. So I asked him to leave, and he went outside, and I went outside too, and he approached me. So that's when I decided to pull it out and fire towards the barn, sir.
Okay. So rather than just stay in your house and shut the door and lock it and call the police, you decided to grab a weapon, walk outside with an argument with the person that you were having. And I think one of the statements you made was that you're 50 years old and you're not going to get into a fist fight with him. So you bring the weapon out and shoot it in the air to make him afraid. Is that correct?
No, I just wanted him to leave the property, sir.
Okay, and why would he leave if he wasn't afraid?
I don't know.
You shot the gun to make him afraid so he would leave.
Yes, sir.
Okay. Counsel satisfied there's a factual basis?
I believe that's what happened, Your Honor. Yes, I do.
Yes, Your Honor.
Are either counsel aware of any other promises, threats, or inducements?
No, Your Honor.
No, Your Honor.
Court comply with the court rule.
Court has.
You have, Your Honor.
I find the plea made is accurate, understanding, voluntary. There's a factual basis, therefore I accept the plea. We'll set this for sentencing on July 16th. So, Mr. Blair, there's several things. We talked about them off the record. I'm going to send you that packet so that you can fill it out and get it returned.
Okay.
You need to show up for the interview and make sure you check with that. I'm also sending you a order for a DNA sample to be taken. Did they take a DNA sample from you at the jail?
Yes, they did. They put a mouth swab in my cheek and my jaw.
Okay, so then we'll check with the police, but we'll have this order in there and we'll check and see at the sheriff's department. If you had that done, you don't need to go do it again.
Yeah,
so
me and
don't
somebody...
go and do it. We'll double check on that.
Okay, sir.
Okay?
Yes, sir.
So you get the packet. You got to send it right back. Then you got to show up for the interview. Then you got to read the pre-sentence report with Mr. Richardson, make sure it's accurate, and be ready for sentencing on July 16th, okay?
Yes, sir.
All right, good deal. Thank you.